Fergus, where are we now on protection against online harms?
Well, the short answer is closer, but not much. The background, just to remind you, is that an online harms white paper was published by the government in April of 2019, that long ago. And the government has now published its response to the consultation that resulted, pressed by the House of Lords, who'd criticised the government for delaying so long. And the background of it is that the EU is pressing ahead with regulation in the form of various attempts by the Commission to regulate big tech. So the UK is getting on with it now, and the government has set its stall by producing an online harms bill or online safety bill during 2021. So the framework is designed essentially to protect consumers and users of online services. It's intended to apply to companies which generate user content or facilitate any interaction between users, one or more of whom is based in the UK. So that's obviously got a vast scope, and it can extend to online message boards just as it can to obvious large providers. There are limited exemptions going to be put in place for small organisations with internal messaging services, but essentially those are designed to be very small. So the big question that UK lawyers are going to need to grapple with once these protections come into force is what will count as harmful content or activity. What's envisaged is a general definition that UK lawyers will be familiar with in terms of its overall parameters, connected to a reasonably foreseeable risk of harm to individuals. That's obviously something that we're potentially used to operating in various other tort-based contexts. And secondary legislation is designed, or is going to be designed, to set out priority categories. So, for example, illegal or harmful content to children, legal content which could be harmful to adults, those will be treated differently. And what's meant by that are things such as self-harm and suicide websites, eating disorder kind of message boards. That's the kind of content which is designed to be filtered by this legislation. There are going to be different levels of obligation on digital service providers, essentially according to what sort of content is in play and what sort of provision is being given, with an obligation to take proportionate steps against illegal content. But if it's legal but harmful to adults, there'll be obligations to monitor more closely, depending on what category you're in. The regulator is intended to be Ofcom, and just as the ICO regime, the intention is to give Ofcom the power to fine providers who are in breach. They're talking about £18 million or 10% of annual turnover, whichever is greater. Also, Ofcom would have the power to block access to content within the UK where it's appropriate. And the government is intending and setting its stall by a global standard, cutting-edge legal standard. It's a very ambitious standard, and as I've said, it's against the backdrop of other jurisdictions trying to apply the same sorts of regimes. It's going to be very exciting to see how those can be enacted in practice.